Now comes the interesting part, the real reason why I conducted this experiment. So, who wins the battle? Hello, counsel. Today's topic is clash of legal titans that has shaped arbitration, the battle between common law and civil law styles. I'm Michael Lee, and in this episode we'll dive into these styles and see who emerges victorious. These are obviously my personal thoughts based on my experience. Due to time limitations, I will often need to oversimplify and overgeneralize concepts. Arbitration is a canvas where legal minds paint their strategies with either common law or civil law colors. Common law counsel often adopt an assertive stance, showcasing their skills through vigorous cross-examinations and passionate oral arguments. On the other hand, civil law practitioners treat a more measured path, relying on meticulous document analysis and the inquisitive nature of the proceedings. One key battleground lies in the world of discovery and document productions. Common law starts with a lean notice of arbitration, preparing for a treasure hunt through extensive discovery. Civil law, however, usually comes prepared with a comprehensive notice, strategically wielding existing evidence and requesting fewer documents. Now, let's dive deeper into a captivating research project I conducted. I conducted a scenario where two common law arbitrators and one civil law arbitrator formed a tribunal. Common law and civil law lawyers presented mock or oral argument before this diverse panel. The results were illuminating. In the first round, the common law lawyer brought an assertive demeanor to the stage, seeking to assert dominance. The civil law lawyer, in contrast, presented a gentler approach, focusing on precision over assertiveness. These initial performances set the stage for an intriguing experiment. So, what did the tribunal think? This scenario produced intriguing feedback. While common law arbitrators leaned more towards appreciating the assertive styles, the civil law arbitrators displayed a preference for the gentler civil law approach. These insights hinted at the subtle nuances that influence an arbitrator's perspective. Now comes the interesting part, the real reason why I conducted this experiment. I asked the common law lawyers to be more civil in their approach, and the civil law lawyers to adopt a more assertive stance. The results were fascinating. The common law lawyer quite seamlessly embraced the civil law approach, and it resonated well with the tribunal. However, the civil law lawyer found it hard and challenging to shed their usual demeanor and be more aggressive. This experiment underscored the power of adaptability in communication. So, who wins the battle? The answer isn't straightforward. As counsel, your strategy should mirror your audience, the tribunal. Recognize their composition and tailor your approach accordingly. The harmonious integration of common law's assertiveness and civil law's precision is the true victor. In arbitration, common law and civil law aren't opponents. They are tools in your arsenal. A wise counsel masters both to sculpt a compelling narrative that resonates with the tribunal, securing victory for your client. As you conduct this strategy, remember that the right approach is always different based on the composition of the tribunal. It'll most likely require that you mix both common law styles and civil law styles. How much of what will vary.